if you have a protective order against you, I know what those say, and I know what the judges and the magistrates tell you about that. No one can judges and the magistrates violate that. No one can give you permission. And if you guys were just talking about, and if you guys were just talking about a visitation of your child cause that has an allegation that there was 96 cause that has an allegation that there was 96 text messages, 47 emails left, 9 voicemails left. And we've got cause numbers 26 DCCR 0373, Mr. Cruz is charged with stalking. Cause number 26 charged with stalking. Cause number 26 DCCR 0374 charged with violating. And then cause number 26 DCCR 1060 charged with violating DCCR 1060 charged with violating a protective order. And the state has filed a motion asking that I increase the defendant's bond. Hold on, I need to see what the bonds are in each case. Hold on, I need to see what the bonds are in all three cases.
I believe 100,000 individual.
In all three cases.
Well, individual.
$300,000.
That's what I need to know.
Individual.
300,000 total.
That's what I need to know. And he has not made bond in any of those. And he has not made bond.
He made bond in the first two.
Correct.
And then he made bond in the first two. The last new case. Picked up and he's in jail on that case. New case. And he's not bond that case.
And the last offense, it looks like has that. And the last offense, it looks like has that date. Same. It was just indicted on, at least on my docket. Let me. It was just indicted on, at least on my docket. Let me look.
It's a different offense date. It's my understanding.
Let me look. Oh, okay. Oh, okay. Well, so offense date. It's not, okay. Offense date. It's not, it's not. So the offense date in that last one is March 1st. So the offense date in that last one is March 1st of 2026 or so after the 2 weeks or so after alleged offense of violating a protective order. Alleged offense of violating a protective order. You may proceed.
Mr. I filed a written motion. I have no doubt the courts reviewed it. I filed a written motion.
Highlights if I may, Judge. Reviewed it. Criminal history. The highlights if I may, Judge. The criminal history. In light of this defendant's criminal history, includes in light of this defendant's criminal history, includes the conspiracy, cocaine, distribution, 2010, unlawful carrying a weapon, 2010, unlawful carrying a weapon, 1994, County Controlled Substance, 1994, in adjudication for possession of marijuana, state adjudication for possession of marijuana, state jail arrest for an aggravated assault, that was arrest for an aggravated assault, probative in this setting, probative in this history setting, and in addition to the criminal history judge has, and in addition to the criminal the fact that this defendant allegedly committed the offense, this defendant allegedly
while out on bond
for violation of protective order,
while out on bond for violation of protective order. I think there are a lot of concerning issues here related to. I think there are a lot of concerning issues here related to public safety. I submit to the court that $100,000 bond. I submit to the court that $100,000 bond. I'm proposing a bond of $250,000. I'm proposing a bond. I'd ask the court to consider $1,000 in this case. I'd ask the court to consider
a couple of PCs as well. Give me just a second. I'm gonna get some stuff printed out. So give me just a second. I'm gonna get some stuff printed out so I can take the PC in both of the in all of the cases. The PC in both of the in all of the cases. So.
You did it. You did it. No.
Y'all stop talking.
Sorry. No.
Y'all stop talking.
Sorry.
Was there one more that printed or not? Was there one more that printed or not? I guess. I guess. Okay, I see. So one of the stalking and protective orders the same. One of the stalking and
That's right.
protective orders the same. Mr.
Yeah,
Parker?
yes.
He said.
That's right.
Mr.
Your
Parker?
Honor, I would like to point out,
Your Honor,
that this is,
I would like to point out that
this
this
is,
is,
and it's
he and his wife are going through a
the
divorce.
nasty,
And it's
part of the
nasty.
part of the communication or contact
Part
with
of the
her communication
was
or
because she
contact with her
wanted him to
was
see the
because
child
she
and told him to come get the
wanted
child.
him to see
And
the
that's why he was
child
there.
and told him
I
to come
think
get the
I can't
child.
just,
And that's why he was there.
And
I think, give me
I
judge,
can't
I haven't
just-
talked to him
after he bonded out.
Give me judge, I haven't
So I don't
talked
have
to
a whole lot of
him
information
after he
and I
bonded
just
out.
received the new
So I don't
case.
have a
I'm
whole
not
lot of
familiar with all the
information, and
facts
I
of the
just
new case.
received the
I'm
new
limited
case.
with what I
I'm not
know.
familiar with all the
But a lot
facts
of,
of the
but
new
my
case.
communication with
what I
him
know.
is that
He's been contacted by her, and I'm sure she was admonished by,
he's been
Judge
contacted
Freeze
by
or
her, and I'm
whoever
sure
that
she was
to not
admonished by
contact him.
Judge Freeze or
But
whoever that
he
did
did
not
say that
contact
was
him.
one of the
But
reasons she has
he did
contacted
say
him
that
to see his
was
child, and
one
one
of
of
the
the
reasons
reasons
she
she
has
has
contacted
contacted
him
him to see his child, and then she tries to use that against him.
There's a divorce going
Which
on.
is common. We see this a lot of times. There's a divorce going on, but you know, we're asking that. I mean, he's on. We're asking that. Felonies. He's on. There's
and $100,000
felonies is a high bond. He had
$100,000 is
on
a
the
high
first
bond.
two cases. I'm not sure if he's going to be able to have
on
that
the
help
first
on
two cases. I'm
these
not
cases,
sure
but
if he's
we're
going to be able to have that
we're
help
asking
on
the
leave the bond the same $100,000
asking
on
to leave the bond the
other,
same $100,000
restrictions.
I think is appropriate for
other
these types of cases.
restrictions.
If he was out and was intended to hurt her, he could have hurt her. If he was intended to hurt her, he could have hurt her.
The facts that
Mr. Coleman has
even
raised in some of the
facts
stuff
that Mr.
is that
Coleman
if he
has
was
raised
around
in
her,
some of the stuff
is that if he was
could have
around
hurt her
her, if he
you know,
wanted to, and
he could have hurt her
if he wanted to,
I think
and aligns with what he is telling us that he was.
I think it
aligns with
shouldn't
what
have
he
gone
was
over
telling us
there
that
to
he
see
was
his child.
even though he
that's
shouldn't have gone
more
over
than
there
likely
to see
would
his
have.
child.
That's
More than likely.
so
would
we're
have.
asking to keep the bond the same, Judge. With
we're asking
other
to keep the bond
monitoring
the same,
restrictions. With other monitoring restrictions.
Right, Mr. Cruz. Right, so Mr. Cruz, if you have a protective order against you have a protective order. I know what those say, and I know what the judges and the magistrates and I know what no one judges and the magistrates violate that. No one can give you permission. And if you guys were just talking about, and if you guys were just talking about a visitation of your child cause that has an allegation that there was 96 cause that has an allegation that there was 96 text messages, 9 voicemails left, 9 voicemails that you don't care what the protective order says, that you're going to do what the protective order says. In addition to pulling in the driveway, in addition to pulling in the driveway, 2 weeks later, February 23rd, 2 weeks later, same thing, the officers locate you in your vehicle, the officers locate you in your vehicle a block away from the house driving past. Obviously, regardless of whether you have already done anything, whether you have already done anything, my job is to make sure that that doesn't happen. And my job is to make sure that feel like you have completely disregarded you have completely disregarded and the rules that were placed on you that was placed on you and the rules that were placed on you down in another court. And so at this time, I'm going to raise the bond and cause number 26, raise the bond and cause number 26, which is the last offense date of March 1st of 2026. I'm going to raise that bond to $250,000. I'm going to raise that bond. Condition of that bond, if you make it. Condition of that bond, if you make it,
GPS monitoring device at all times.
wear a GPS monitoring device at all times
as well. So you
and
would
that
not
you would
be
be
allowed
on
to
house
leave
arrest
your
as
house.
well. So you would
I
not be
am going
allowed
to modify
leave
the
your
conditions
house.
of your bond.
I am going to
and the
modify
two
the
other
conditions
cases that
you've
you've already
already
made
made
bonds on.
and the two other
Additional
cases that
bond
you've already made
conditions
bonds
in
on.
those two
Additional
cases,
bond
which is
conditions in those two cases, which is 2674, are that you have a GPS monitoring device on at all times and that you are on at all times and that you are on house arrest.
All right,
You're not
you
allowed
can
to
go back
leave
with the
your house
bailiff. We'll
without
set
my
your case for an
permission.
announcement.
All right,
The
you
bond
can go
amount
back
stayed
with the
the same
bailiff.
in
We'll
that
set
one?
your case. Yes, I didn't change those
The bond
bonds
amount stayed
amount.
the
I
same in
raised
that
the
one?
last.
Yes, I
I
didn't
didn't change those bonds amount. I raised the last one and made those modifications.
Train house, he's not putting to be. Train house, he's not putting to be.